briefly speaking, with me, Tarun Nangia. Now we are continuing our series titled India's Top Litigators. And today I have a litigator who's a top litigator at the Delhi High Court, which you know is a place where all top commercial disputes of India happen at the Delhi High Court, and he's one of the top counsels of Delhi High Court. And I was just going through in the recent past the clients that he has appeared for, and there was no name that I thought of that wasn't his client or he didn't appear for. The list leads like Apple, which is the most recent, which I found out, the Adani Group, the GMR Group, Tata's, many companies of Tata's, in fact, ArcelorMittal, Amazon, which is a tech giant, DLF in the construction industry, Kishore Chhabria, Flipkart, Dabur Group, that's in the Ayurveda business, Amazon, again a tech giant, Birla Group, Tata Consultancy Services, Air India in the aviation sector, SpiceJet, and of course the Amazon case where Amazon versus Future, where he, in fact, there are many other big cases which I won't give out in the introduction because I think that we would like to reserve for the show. Let me welcome India's top litigator, Senior Advocate Rajiv Nair. Good to see you, and thank you for your time.
Thank you, Tarun, for having me on your show. And
see, first come first, I want to ask you about some of the recent cases in which you appeared before I move on to your story in the past few years, which you consider as one of the top cases that you have been a part of. Could you share a few?
So you mentioned Amazon last. So let me start with Amazon first. It was a litigation which was really close to my heart. About a couple of years back, it developed because you would recall, and your readers, viewers will recall, that Amazon entered into a binding agreement with Future Group in relation to acquisition of its stores, and then Future backed out, and then there was an arbitration, emergency arbitration proceeding in CX, and the question was whether that arbitration our interim order was enforceable in India or not. So Justice Nariman eventually in the Supreme Court, in a very path-breaking judgment, said that emergency arbitrators awards are enforceable under Indian law. But that was in the Supreme Court. So I actually got involved in the Delhi High Court. They had this agreement, and I remember that when I was instructed by AZB and when their legal head also came to meet me, and they said, we have this order of the emergency arbitrator, what are we supposed to do? So I said, do you want to keep it framed? Then you can frame it anywhere, even in my office. I recall telling them. So what is the point of having an emergency arbitrator's order if you're not trying to enforce it? So then we decided to enforce it in the mechanism of Section 17(2) as a order of a tribunal. This is the first time it's been done in the history of India, because normally it was a gray area before that. And our first encounter in this litigation was Justice Midda, who answered in our favor. I mean, we had a galaxy of lawyers on the other side: Mukul Rohtgi, Harish Salve, Gopal Subramaniam and I were on one side, in this side. And Justice Midda held it to be enforceable. Then the matter went in appeal to Justice Patel, and less said about that order, because according to us, that order was not appealable. But answering for the bench, he held it to be appealable. But I don't want to comment much on the appellate side litigation. Then eventually the matter was carried to the Supreme Court, where we had the good fortune of having Justice Nariman, steadfastly honest with integrity, and who develops the law. And he answered in our favor and said that the award is enforceable. And then started the, we started getting protective orders, etc., from the court. And there was an offshoot in NCLT Mumbai where there was a winding IBC proceeding instituted by the creditors against Future. So we moved an application under Section 60, subsection 5, saying that it's a collusive litigation and there should be no IBC proceeding against the company, because the idea was that Future was trying to get the protection of IBC and then hive off the stores, which it eventually did to the Reliance Group. So I had the occasion to connect virtually with NCLT Mumbai, and I remember connecting from Taj Palace. We had taken a conference room there in Taj Palace, and we had multiple number of hearings. Eventually, we lost, but that was a great litigation. Some offshoot is still pending. We are waiting. The matter eventually arbitration award is reserved. So hopefully, if we have an arbitration award in our favor, the next difficult part will be to enforce that arbitration award in India against the Bianis.
Thank you for that introductory comment. When I was researching for this show, I also found out that you had your own part to play where you appeared for the Ratan Tata side in the Tata versus Mistry dispute. This is one of the biggest litigations of the corporate side that India has seen. How was that experience being part of that dispute?
So I wasn't involved in the NCLT Mumbai, but the matter when it came to NCLT Mumbai, Delhi, I had the good fortune to be a part of it. But I mean, there were lots of us. Harish Salve was there, Abhishek Singhvi was there on our side, and but the reason why this litigation is important is because that's my first real good contact with the Tata Group. Actually, the Cyrus Mistry was represented by Arun Jaitley's daughter, Sonali Jaitley. So she had actually approached me first, but I said, no, I'll go with the Tatas. And I eventually ended up being on the team with the Tatas. And of course, the NCLT gave a peculiar judgment, which was eventually corrected in the Supreme Court. But it was great fun because there were multiple hearings, and it was a matter which was argued for many days, and it was a good litigation to be part with too.
And
I wasn't there in the Supreme Court, but I was there in the NCLT.
One interesting litigation that you were part of when researching, I found out, was the officer's choice versus green choice whiskey dispute. Could you share some? Because this will be pretty interesting because you do so many of these top matters. Some are like, no, this is pretty interesting because it involves food and drink.
So actually, I've been associated with the Kishore Chhabria group ever since they moved away from the Manu Chhabria. So there was in 1992 or 1993, there was this litigation between Manu Chhabria and Kishore Chhabria. And just on an aside, before I tell you about the green choice officer's choice. So in this litigation, apparently, this litigation was pan-India. There's some in Bombay, some was in Chennai. I mean, there were actually, as I recall, as somebody had told me at that time, there were 102 litigations between the two brothers. And then there are lots of judges and their relations were conflicted. So matter eventually came to the Supreme Court on a transfer petition. And apparently, when the transfer petition came to the Supreme Court, Justice K. Ramaswamy was on the Supreme Court judge, and he sent for a map of India. And he said, where I'll just place my finger, and wherever my finger finally arrives at, I'll transfer the case to there. So his finger finally found Delhi, and all the litigation was transferred from all over India to Delhi. And it was it was a bonanza for me because I was just 10 or 12 years in the profession by then. And it was one of the most major groups to have. And there was so much litigation, Chandigarh, Allahabad, Delhi, that I was busy for many years. Eventually, the litigation got settled, etc. But my relationship with the Kishore Chhabria group continued. And there was a multiple, intellectual property disputes, because officer's choice has now become one of the world's largest selling whiskey. And we have these clones of choices coming up every now and then. And we had to go to court to stop it. The green choice was the biggest litigation in recent years because it was being by financed by Green Choice, who's apparently some politician in Andhra or something, and they were spending a lot of money on the litigation. They were spending, they had huge, lot of lawyers, and they had managed to get approvals from excise authorities. And I think the matter was eventually decided by Justice Jyoti Singh in an interlocutory. And I could see, one thing. I mean, I'm not praising myself, but one thing I get a sense of, I can read a judge at least 90% of the time. So, I mean, I have this capacity of trying to, I'll tell you about it later, but I have this capacity of being able to read a judge. And I could sense that she was against us, because she said, how can anybody appropriate the word choice exclusively, as long as there are different packaging, different. But then I stressed on dishonesty, etc., on adoption, etc., which turned the table, and eventually we succeeded and the injunction got confirmed.
Interesting you say this, because they say that one of the qualities of top senior counsels is to be able to read the mood of the court and respond accordingly. Do you think years of practice of, for the high stake matters has given you that ability to read a mood of the court and present the fact that the judge wants?
No, I think, of course, it's actually the credit goes because, when I started, then I believed in maximizing my numbers.
So you have done a lot of litigation.
So I did. I mean, I've done about for many years. I kept my fees low, and I used to do anything between 20 to 22 cases in a day.
Every day?
Every day for at least 10 to 12 years of my life, I did 20 to 22 cases a day. I mean, I don't know how many I reached, but I used to have a list of 20 to 22 cases. The idea was that I wanted to make an impact in the court, and maximum appearances means the maximum rapport with judges. So, the familiarity with judges. And I think in that period, I developed this uh, instinct of being able to read judges. I mean, I'm not right all the time, but most of the time when the judge is reserving orders or about to give orders, I am able to anticipate which way the judge is going.
So comes one more follow-up question. How important is for you able to be to gauge the mood of the court as a top litigator? Because what fact you present before the court is depending on what the judge is actually wanting out of you, to, in a sense, for him to be able to understand. For example, you have a briefing note or things of say 150 pages. You can't speak all that 150. The judge time is precious. Do you think is that ability to decide that how many points to put forth, is that skill that the top senior like you has?
So, well, that's one of the things, but a counsel must be able to gauge the judge to mold his arguments accordingly.
Okay.
So if you are pitching for 100% order, the judge is not that much in your favor. So then you tone down what you are asking for. Because I believe that every time I appear, I must get something or the other for my client, because he's paying for me. So even if you get half, you get 1/3. So that's the position that you are able to get for your client. So I've touchwood been quite successful in that aspect. And people, people do say, I don't want judges to see it and they'll show it, but I'm quite good at getting interlocutory relief in the Delhi.
Okay. Point well taken. One thing I want to know, you appeared for what is one of the biggest steel companies, or the biggest actually steel companies in the world, ArcelorMittal. That's by far the #1 steel producer in the world. What matter was that, or what kind of matters did you do for them?
So I was involved in their acquisition of their steel plant through IBC.
So the SR Steel, which they took over.
SR Steel one. So I was on their side, and we were. I had occasion to go to Ahmedabad also once or twice. That's my first brush with Ahmedabad in the NCLT. But I largely was here in the NCLT in that SR litigation, which eventually went in favor.
One thing a lot of people want to also know, and people discuss in when they talk about you, is that you were one of the few lawyers who have refused an ASG post, which is the Additional Solicitor General of India post. When did that happen, and why did you choose only practicing in a sense as opposed to taking a government appointment?
No, so that's not quite true, because this ASG is in two parts. So I remember Arun Jaitley asking me informally whether I'd be interested, which I said no during this period. But you see, when I must share it with you that when Mr. Inder Gujral became the Prime Minister, I think somewhere in the year 1998 or so, at that time, I was being sounded for the additional solicitor post in Delhi High Court.
So 96.
I think 1996 then.
96.
And at that time, I was interested, and the Prime Minister cleared my name, and Ashok Desai was the Attorney General. He was very keen. I remember, along with Ryan Karanjamala, who's a good friend of mine, I had went and met the Law Minister, who was Ramakant Khalab at that time. And I wasn't a senior. So my senior designation was also rushed through at that time, because you needed to be a senior to become. And there was some article in the newspaper by saying all Prime Minister's men, and eventually my name was dropped. I never became an Additional Solicitor General. So when my name didn't figure, and I remember it was the beginning of the summer vacation, and my good friend, late Arun Jaitley, rang me up and said, "What's the program now? So will you become a senior?" So I said, I was quite crestfallen. I was quite depressed, and I said, "I don't know." So I remember his words, and he said in Hindi, "Ab rone se kuch nahi hoga." He said, "Cancel your summer plans and stay put and appear in the vacation courts, so that you register your presence in the Delhi High Court." And that's what I did, and there was no looking back after that. I value his advice even today.
Point very well taken. One thing that I would want to know from you more is your appearance for Dabur. What kind of matters? Because Dabur is a very, very popular company in the Ayurveda sector, very trusted, and a household name for decades now.
So actually, Dabur is basically has intellectual property disputes, largely on infringement, largely on passing off, and there are these 3 or 4 competitors. So I have this ongoing litigation with Imami, and so that's basically what I do for Dabur. I appear off and on for the intellectual property disputes and trademark disputes.
GMR also, you've done some work. Any specific disputes for GMR?
I've done off and on, but I think the biggest litigation I remember for GMR was that there, in Delhi airport, there are 3 terminals.
Yes.
T1, T2, and T3. And there was a litigation where Go was being relocated to T2. And Indigo filed a litigation saying that Go should not be there and give T2 exclusively to us. And I appeared for GMR, and the court decided in our favor and said there can't be any.
So basically, this was the Indigo versus GMR fight, where Indigo wanted.
Yeah, Indigo versus GMR fight.
That was a big fight. I remember, I think 5 years ago.
Yeah, the Rahul Bhatia has never forgiven me for that.
So one thing that I would want to discuss you for DLF is one of India's largest real estate companies, one of most famous and most respected in that sector. What kind of appearance? Because on the one side you're doing IP. What work would you do for, say, a construction giant?
So they had some arbitration disputes. They have lots of. They have the one dispute going on with a Bombay builder, which is part here, part in Bombay. So DLF is a big litigator off and on. You know, they have disputes. This is interesting that you bring this up. The one of the things about me is that except for criminal law, I've sort of done pan all sort of litigation, trademark, corporate, company. So I believe that don't say no to any litigation. I mean, you are not a specialist of any, so I do all sorts of things. IP. I mean, basically, I'm doing lots of commercial litigation, and that's according to me quite forte.
Point well taken. Your most recent litigation is a company that's, I think, by far the biggest company in the world today. For Apple, you appeared. What was that litigation?
So there's an infringement action instituted by one company against another company, where Apple intervened by saying that this infringement action should not succeed. I mean, there's a bit of confidentiality in that litigation, but except for the fact that Apple is saying that there's no infringement. That's the first major litigation, I think, big litigation of Apple in Delhi. And I'm glad they reached out to me.
See, one of the true hallmarks of a true professional is the ability of appearing for a client and against a client. And I've seen that for the India's biggest companies, in one case you're against them, in another group company you're for them. Do you think that you count as one of your assets, that for some of the top corporates, be it Adani's or be it Reliance, in different companies you may be, in one case you're for or against? Do you think that's the true test of being valued as a top senior, that companies
No,
want?
that you are right, is a true test. But you know, Tarun, I've had a long career. I mean, I started in 1979. I can narrate my beginning with you in a little while. But during the course of 79 to 24, there's a sea change. People are not that receptive, even if you appear against the group companies. So you basically, if you are with Adani, then you can't be seen appearing against Adani the next day, or GMR. So you know, it's basically becoming in that sense that if you appear for a particular group, then it's very difficult for them to accept that you start appearing against them. I find it difficult now to appear against Dabur. And I'll find it very difficult for Imami to accept me because I've appeared against them. So even though there's no such bar, I remember for many years ITC was not using me because I think I had advised Sohail said once against this defamation action. But after the litigation was settled, etc., and I started appearing for them. So people are sensitive about.
But by and large, you have been able to somehow, in not if these clients, other clients you've managed, that they still like to engage you, even if you have in the past.
So, you know, corporate clients have come over the time because I remember when I started, I used to start with individual clients. Most of my clients were individual clients. I used to be a filing lawyer as well as an appearing lawyer. And then eventually, after the force of circumstances, as I told you in 1996, I was forced to become a senior. I didn't actually intend to become a senior. And God has been kind to me since then. And I mean, I haven't looked back. But just to share that my initial years, I started I used to work in Khetan for some time. Before that, I was working with a central government standing council. And my initial years, I operated out of a 30 square feet office in Sundarnagar, where I was staying with my father. And then eventually I moved to a 100 square feet office in municipal market, above those car workshops. And my real first office was a rented house office in Nizamuddin. And my first office, which I acquired, was the year 2000, after 21 years of my a ground in basic and defense college. So, I mean, life was hard, and it's not easy to make a success of. Because nowadays everybody thinks that grass is greener with lawyers, but it's not that. It takes a long,
I
long
mean,
time, and
success, the Jorbag office and all, it's come a hard way. It's taken its
yeah,
time.
and I believe, I mean, that it's good luck, because also, I mean, everybody works hard, everybody is the same intelligence, maybe one step here and there, but this is God's blessings that we have got.
As a top counsel, if you could share me one thing with the viewers, actually. Unlike a industry or a plant which you can delegate to the CEO, they say a top counsel still has to work every Sunday, every day to appear the next day. What is that quality that is required for someone to be a top counsel? Is that ability to put in work every day, even even after you've been successful for a long time?
So I think there are two or three facets of being a good counsel. One is, of course, working hard, which everybody does. I mean, I still have 10, 12 hours working days.
Every day.
Yeah, even now. Second is, I think the thing is to grasp the point quickly. I have somehow done many matters in court where I have been briefed in the corridor and then I have appeared before the judge. I mean, not now, but in earlier years, I have been done many matters where I remember 5 minutes, 10 minutes briefing, and then I went inside the court. So the ability to pick up the sense of the matter is a big thing which goes a
It's
long way.
called thinking on the feet. Can you say you have to think on your feet? That what instant
Yeah, of
can
course you
you?
have to think on your feet, because think on your feet is very important, because you have to modulate your arguments in accordance with what the judge is thinking. So you may have gone with a prearranged argument, which you may have to taper off as things go. And that's why I feel that there are lots of counsels, but the capacity to think on your feet. I mean,
One thing that I am interested in, Ram Jethmalani argued in the Supreme Court till his 95th birthday. When he was 95, he was doing big matters before Supreme Court. Fali Nariman was doing constitutional matters, big matters before Supreme Court at the age of 95. Uh, in today's list, K.K. Venugopal still stands before the bench in Supreme Court and argues for 1 full hour. It's indeed admirable. I have seen that you moderated your client list. Uh, you moderated your client list to appear for basically new age companies. You Amazon, Flipkart, Google, Apple. Your list is all the new tech companies which are companies of the future. So do you think in a way you also are changing with the times so that your client list also reflects that? I mean, you're not talking old economy. When I spoke to you, speak on new economy companies, and you're speaking of IP disputes, which actually have become big in the past few years only.
so I think this has happened on its own. Haven't done any effort to make it. But I don't know which is the age which I will retire at, because I remember I used to say I'll retire at 60. Now I'm 67. I have still no instinct to retire. But I don't think I can go on till 90s as Pali Nariman or Venugopal. I mean, they'll have to be an age somewhere in between where I have to stop.
Okay, okay. But do you think you're, if I study your client list, I see you vary it and get the new people or the new kind of client. Do you think that excites you? This is because see, some people, they're landlord tenant lawyers, they are lawyers who appear for a certain kind of client, they're builder lawyers. Your list doesn't look like you're like a lawyer for every new kind of company and every old kind of company.
So, Tarun, the point is that I enjoy my work, and I enjoy working long hours. I enjoy my work, and I mean, despite the fact that I've been 44 or 45 years into the profession, I still hate it when I lose, and I am really elated when I succeed. So, that's the kind of excitement normally people have when they're 2 or 3 years in the. So I'm not detached from my clients in that sense. So that I still have the feeling of as if I've just entered the profession, the same kind of excitement I used to have earlier.
It was an interesting discussion with you today, and I look forward to talking to you next year, same month, of course, with a new list of clients that you have acquired and represented, some new tech companies, some new IP disputes, and some new corporate battles. Because as our economy grows, the disputes are going to go bigger, is what all the law firms tell me all the time, that Tarun, the big disputes are yet to come because numbers are only growing.
God willing. God willing. Thank you.
Appreciate your joining us. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.